Good morning. My name is Malcolm Neekirk. Welcome to Fretton's fifth coffee break briefing of 2025. I'll keep this morning's introduction brief. I'll give you a list of dates for your diary at the end that will include our annual conference on the 13th of June. The theme for that is boardroom bust-ups, looking at the effect of internal tensions on businesses. And we also have a guest speaker to talk on the uses of artificial intelligence in insolvency practice. That does mean there will be no coffee break briefing in June, with the next one being scheduled for Monday, the 7th of July. Today, we're going to be talking about the theme of provisional liquidations. Let me put the slides up for you now. There are four aspects that I'm going to be looking at. I'm going to start by looking at what I'm calling companies in a contingent state. And this is the situation of a company that is running under a winding up petition. A petition has been presented against it, but no winding up order has yet been made. And it's against companies like that that provisional liquidators can be appointed. I'll then be moving on to look at the powers of provisional liquidators, following that up with some uses for provisional liquidations, and then finishing by trying to answer the question, why do we see so few provisional liquidations? Generally speaking, today's topic is really a background to the advisory work that we do. A provisional liquidation is one of the statutory procedures that may be appropriate in any number of situations. And we need to know and understand about provisional liquidations, if for no other reason than to make sure that we rule them out appropriately when they're not appropriate to use. So let's start by looking at what I'm calling companies in a contingent state. And I'm drawing an analogy here from quantum physics and the idea of Schrodinger's cat. And I don't understand much about quantum physics, but as I understand it, time works in a really weird way in the quantum world, which means that something cannot actually be regarded as having happened until the point where a physicist gets his clipboard out and makes an observation to see what happened. And at that point, the uncertainty collapses and you find out that something did actually happen before the observation was made. And this is demonstrated in a thought experiment where a cat is locked in a sealed box with a flask of poison, and the poison is released if a quantum event happens. And because that quantum event only happens retrospectively when the physicist looks at the event, it means that the cat is simultaneously both alive and dead within the box, because the flask of poison has both been broken and not broken at the same point. And I think that's a useful analogy for what happens to a company when a winding up petition has been presented. And again, this diagram is a spoof of a Feynman diagram, which is used in quantum physics to show the interaction of particles. So here we have a company, a corporation, being hit by a winding up petition. And the result of that is litigation. And this shows what happens if the litigation is successful. A winding up order is made, and we now have a company in liquidation, and there are professional fees that are generated as a result of that. Of course, it's not inevitable that a winding up order will be made once a winding up petition has been presented, and it's quite common for a petition to be dismissed or withdrawn without a winding up order being made. And in this case, we see here winding up petition being presented with a corporation, litigation resulting from that, the petition being dismissed or withdrawn, and the corporation then continuing in its existence unaffected by the winding up petition. No winding up order has been made, and in this particular case, professional fees are wasted. So we've got a negative against the pound sign there because money has been spent without achieving the desired objective. Now, the crucial thing here is, this is why the Schrodinger's cat analogy is appropriate, is because when a winding up order is made, it is treated then as having retrospective effect. It is backdated to the date of the petition. So the commencement of the winding up is the date that the winding up petition was presented, not the date that the winding up order was made. A couple of minor exceptions to that rule. If the company went into a voluntary liquidation before the winding up petition was presented, then the winding up is treated as starting on the date that the resolution was passed to put the company into liquidation. And if the liquidation follows an administration, then the compulsory liquidation is treated as starting on the date that the winding up order is made, so that you don't have an administration and a compulsory liquidation running simultaneously. But it's this retrospective effect, which means that if a winding up order is made, the company is treated as having been in liquidation perhaps 6 weeks earlier, maybe even longer than that, without anybody at the time necessarily having realised that that was the case. That gives the analogy with Schrodinger's cat. You have Schrodinger's company, which is, during this period while the petition is running, the company is both simultaneously in liquidation and not in liquidation. And of course, we've got the diagram here to show what happens if the petition is withdrawn or dismissed. And in that case, the winding up petition has no effect. The company has never been in liquidation, and it continues in effect without any great consequence from the petition. Of course, you won't know while the petition is running which state the company is going to be in at that time. The result of this period of uncertainty is that certain things are affected by the petition, and I'll have a look at the effect a petition has on litigation, on enforcement by creditors, on dispositions of property, and the powers of directors in that time. So, starting to look at litigation first. This is an effect that the petition has while it's running, and is not dependent upon whether a winding up order is made or not. But while the petition is running against the company, the court has got the power to stay any litigation that's running against the company. And the general presumption is that the court is likely to stay litigation, and in fact other parties to litigation, if they know that there's a winding up petition running against a company, they're perhaps not going to be that keen on continuing with the litigation anyway, because of the risk of getting a Pyrrhic victory and them simply being an unsecured creditor who spent a lot of money to get their position in the queue. Enforcement by creditors after the commencement of the winding up is void. Now, because it uses this phrase after the commencement of the litigation, this does mean that the voiding of enforcement by creditors is conditional upon a winding up order being made. So a creditor can take enforcement action, can send the bailiffs in, can seize goods while the petition is running. If a winding up order is made, that will all be ineffective. If a winding up order is not made, if the petition is dismissed, then the enforcement will remain valid. Similarly, dispositions of property by the company after the commencement of the winding up, after the date of the petition, if a winding up order is made, are void under section 127. And this, of course, is a very powerful tool for compulsory liquidators to claw back assets, property, money that has left the company after the date of the winding up petition. The powers of directors are only suspended by the liquidation when the winding up order is made. So while the winding up petition is running against the company, even if a winding up order is made on it, the powers of the directors continue unabated. So it's a strange sort of liquidation that you've got when a winding up petition has been presented, in that although property dispositions are generally void, enforcement actually is generally void. Nevertheless, the director's powers do continue without any other restriction, and therefore the directors have got the power to dissipate assets, do damage in that period. Of course, there is another critical stage in the winding up process, and that is the date that the petition is gazetted. It's advertised in the London Gazette. From that point, it becomes public knowledge. The banks in particular will know about it, and because of the implications for the banks of Section 127, they have to freeze the company's account as soon as they know there is a winding up petition running against the company. And that has a very real, very practical effect on the company, that once the petition has been gazetted, the bank account is frozen, and it then becomes very, very difficult for the business to continue trading beyond that point. So back to the topics. That's a look at what I call companies in a contingent state while there's a winding up petition running against them, and which may or may not result in a winding up order. That's the period in which it is possible to appoint a provisional liquidator. So let's move on now to look at the powers that provisional liquidators can have. 4 aspects of this I'm going to look at: when you can appoint a provisional liquidator, who can be a provisional liquidator, what powers a provisional liquidator has got, and then perhaps most important of all, why on earth would you want to appoint a provisional liquidator or take appointment as a provisional liquidator. So the wording in the Insolvency Act is quite interesting. It starts off by saying that the court may appoint a liquidator provisionally. So where you first come across the idea of a provisional liquidator, they're not actually called a provisional liquidator, they're called a liquidator appointed provisionally, which is an interesting nuance on that. Key thing is the window of opportunity for appointing a provisional liquidator opens when a winding up petition is presented, and it closes when a winding up order is made and the official receiver is appointed as liquidator. So it's that period of time while a petition is running. And of course, if it makes sense to appoint a provisional liquidator, it normally makes sense to appoint a provisional liquidator as early as possible. So generally speaking, when provisional liquidators are appointed, they are normally appointed on the day that the winding up petition is presented, and they therefore are in office for the whole period of time that the winding up petition is running. Insolvency practitioners can be provisional liquidators, so too can the official receiver. Now, the legislation actually says that it can be either the official receiver or any other fit person. In practical terms, that's likely to mean an insolvency practitioner, but it would be possible for somebody who's not an insolvency practitioner to be appointed as a provisional liquidator. And one interesting consequence of that is, suppose that you have the situation where you and a colleague are appointed as provisional liquidators of a company. You take office on the day that the winding up petition is presented, and you remain in office for maybe 6, maybe 8 weeks until the date when a winding up order is made. On that day, winding up order is made, a liquidator is appointed, and by statute, the first liquidator has to be the official receiver. So you immediately find yourself out of office, in effect. You've been in charge of the company's affairs for the last 6 or 8 weeks. Winding up order is made. It now is the official receiver who is appointed as liquidator. In many cases, the official receiver will be very willing to make a Secretary of State appointment very soon after they are appointed, and very often pass that appointment back to the provisional liquidators. But that's not something that can be done immediately, and the court has got no power to appoint anybody other than the official receiver as liquidator when a winding up order is made. So the way to bridge that particular gap, one method that's very often used, is for the court, when it makes the winding up order, to appoint the former provisional liquidators as special managers with powers that give them then continuity with the tasks that they were engaged in immediately before the winding up order was made, acting under the supervision of the official receiver as liquidator, of course, with then the official receiver perhaps then stepping aside and making a Secretary of State appointment at the earliest convenient date after that. But that's a common way of bridging that particular gap. So what powers would you have as a provisional liquidator? And this is an area where I think the terminology of the Insolvency Act is perhaps a little bit confusing. We have the official receiver, who is not a receiver, but is either a liquidator or a trustee in bankruptcy. And I think actually it's more accurate to think of a provisional liquidator as not being a liquidator, but as being a receiver, because there are no statutory powers that a provisional liquidator has. And like a court-appointed receiver, the powers that a provisional liquidator has are those conferred on them by the court order under which they are appointed. So it's really important to make sure that that order is drafted with a great deal of care to give you the powers that you are going to need as a provisional liquidator, and incidentally to make sure that there are proper arrangements for you to be able to charge your fees and expenses as provisional liquidator. And it might be that Schedule 4 powers, which a provisional liquidator does not automatically have, but those Schedule 4 powers might be a good starting point for drafting the powers that a provisional liquidator will have. Court order appointing the provisional liquidator can also limit those powers, so they may not be as extensive as the full Schedule 4 powers, even if they are granted. And what are the main reasons for appointing a provisional liquidator? Well, two connected reasons, really. Firstly, to limit the director's powers, because otherwise the director's powers do continue until the winding up order is made. And secondly, and the most usual one, is to preserve the assets of the company. And this can be either fairly mild, in the sense that you might have a company where you're looking to organise an ordered wind down of its business, or they could be quite draconian powers where you're perhaps fearing that the directors are dissipating the assets of the company, and that to protect those assets, you just need to make sure that they are placed in the hands of an independent third party, perhaps even with additional powers to try and recover those assets. So let's move on from looking at the textbook powers of provisional liquidators to see what uses there may be for provisional liquidators in the real world. And I've got this list of 4 here. There may be others. First one is to preserve the company's assets. The second one might be to preserve the company's records, and it could be that you're looking at a situation where the directors have already stripped the company bare, but you just want to make sure that you've got hold of the servers and that you've got the ability to grab hold of the records to secure them before they too disappear and the trail goes completely cold. Traditionally, they've also been used quite frequently in insurance company insolvencies. And another case for using them might be as a powerful first strike in litigation. And if you've got a creditor who is looking to recover assets, then it can be extremely useful to go straight into the defendant company and change the people who are running that from the directors who are perhaps responsible for whatever your claim is in the first place, and replace them with independent insolvency practitioners who will be neutral and will act within the law in administering the company. And I have seen cases reported where not only has a provisional liquidator been appointed on day one, but the provisional liquidator has then gone on to get freezing orders on assets that have disappeared from the company in the period before the winding up petition was presented. So you've got a sort of double first strike there of the provisional liquidator plus then freezing orders launched not by the creditor directly, but actually by the provisional liquidator on behalf of the company that's lost the assets. So it can be a very, very effective first strike in litigation. Looking at each of those in terms, first one, preserving the company's assets. This is essentially what it is all about. So this is the main reason for having a provisional liquidation. And as I said before, this can either be because you want to wind down the affairs of the company in an orderly manner, or it might be because you're actually looking to claim back assets that have gone and prevent further dissipation of assets. Now, I've just got a question that's popped up, so let me see if I can. I'll perhaps pick up those questions at the end. But carrying on with the reasons for a provisional liquidation. First one is preservation of assets. Second one is to preserve the company's records, which would be important in something like a public interest liquidation. And of course, you get winding up petitions that are presented on public interest grounds, particularly if something like fraud is suspected, and there it might be useful to make sure that the provisional liquidator has got powers to take possession of the company's records and secure them. I mentioned insurance company insolvency, and it used to not be an option for dealing with the insolvency of an insurance company to put them into administration. There have been changes to the law that does mean that that is possible, but there may still be advantages to a provisional liquidation because, for example, an administration will crystallize the date on which exchange rates will be set for the duration of the administration. Provisional liquidation does not do that, so you don't have the same risk of exchange rates going the wrong way in a provisional liquidation that you do in an administration. Normally, a provisional liquidation would be used simply to put a moratorium around the insurance company, leading up to something like a scheme of arrangement or more recently a restructuring plan. And it might be possible to use something like a statutory moratorium in the run up to that as well. And I've talked about a litigation first strike as well as a way of a provisional liquidation, allowing the creditor effectively to change control of the debtor right at the outset of the litigation and back and build from there to freezing orders that go further than the creditor themselves might be able to take it. And it's worth remembering in this context that it's possible to put a partnership into liquidation, and it's therefore possible to appoint a provisional liquidator of a partnership as well as it is of a limited liability company or an LLP or other types of body corporate. Provisional liquidation is always going to be a high-risk strategy, and that's because there is no guarantee you're going to get a winding up order when the petition is finally ruled on by the court. And if the court decide that they're not going to grant a winding up order, you've then had provisional liquidators appointed over a company which has not gone into liquidation, and whatever damage has been done will have to be unscrambled by somebody. And that is where the risk comes in. You've got to be very, very sure that you're going to get a winding up order to be thinking about having a provisional liquidator appointed. So, final question on the list of topics is why so few provisional liquidations? And I've probably just answered that. It's because they are risky, with the risk that orders may be refused or discharged. and because they are expensive, because you have to do a lot of preparatory work to convince the court to appoint a provisional liquidator. Somebody has to fund the work of the provisional liquidator, and you may not know very much about what assets are actually going to be available within the company to fund a provisional liquidation when the liquidator is first appointed. I've also got the comment there on the slide that you need inside information. You need good intelligence about what has been going on in the company, where the assets are, where they might be, to make it worthwhile thinking about a provisional liquidation at all, and to convince a court that a provisional liquidation makes sense. And you might find that other procedures will work well enough, so an administration might do the job, perhaps a court-appointed administrator, depending upon the circumstances, may be better, more appropriate than a provisional liquidation, depending upon the circumstances. So that's basically covered the points that I wanted to cover. Summary slide, I suppose. Provisional liquidations, the purpose of them is to protect assets and also company records while a winder is running in the run up to a liquidator being appointed in a compulsory liquidation. Insolvency practitioners can be appointed as provisional liquidators. It is for the court to set the powers of provisional liquidator. They're not defined by statute, and provisional liquidations are inherently risky because you don't know what order the court is ultimately going to make, and therefore that's the main reason why they are uncommon. Now move on to the questions. First question I got from Mark Newton, thank you for this, Mark, is asking whether the bank needs to consent to a provisional liquidation. Secondly, who then approves any fees resolution? Well, first thing is, no, the bank don't need to consent to a provisional liquidation. It is a court order. As a creditor, the bank would be entitled to be made aware of the winding up petition, and they would be entitled to appear. Now, whether they would hear about the winding up petition before it's advertised would depend upon the circumstances, whether you need to advise them of it. And in terms of who approves any fee resolution, well, it's the court who will deal with the fees of the provisional liquidator. But as with a court-appointed receivership, you're going to have the problem that if there is a secured creditor, you're not necessarily going to be able to use the creditor's security or jeopardize the creditor's security by taking fees from assets that are caught by the creditor's security. So in many cases, the provisional liquidator is going to need to come to a funding arrangement with the creditor who is appointing them, as well as getting their remuneration approved by the court. And of course, the risk for the creditor who appoints them is that if the winding up order is not made, then they, as the creditor, are going to be responsible for picking up the fees, as well as possibly paying compensation to the company who's been improperly put into a provisional liquidation. Don't see any more questions. I hope that's a helpful answer. So I'll just move on now to give you some dates for your diary. And in a couple of weeks' time, we've got the SESCA Insolvency Seminar at Denbies, so I hope to see some of you at that. Friday the 13th of June, we've got our Insolvency Conference in the New Forest. Hope to see lots of you at that. Please do sign up for that if you haven't already done so. Kirk seem to be running a very good insolvency course. This is the second year they've done it, I think, and they're putting it on in Maidenhead in June, which looks like a good program to go to. I'd also mention the SESCA Insolvency Conference at Reading in September and the second seminar at Denbies in October. And I'm intending to go to the R3 SPG Forum in Stratford in November. So thanks for your diary there. Thank you all very much for joining in on this with me today. As I mentioned, there won't be a coffee break briefing in June, but there will be in July. And I do hope to see you at the conference, if not before. So thank you all very much, and goodbye.